Good morning. The judgment which I am going to discuss today is most important judgment for defense lawyers, criminal side practitioners, particularly POCSO cases, and for law scholars who are pursuing postgraduate law or pursuing doctorate, or you intend to be a researcher. This judgment will definitely give enormous feeding materials. Because the judgment was arising out of Justice Anand Venkatesan judgment, who quashed the charge sheet filed against a man for having seen pornography. So, by extending Section 30 presumption, therefore, the Supreme Court, not earlier, the media published stating that his judgment was criticized. His judgment was not criticized. It extensively interpreted purpose by using purposive interpretation, keeping in mind the importance of these cases being filed. So you must go through the multi number of pages, multi number of paragraphs, more than 250 paragraphs are there. This is AAR 2024 Supreme Court 5531. AAR 2024 Supreme Court 5531. Just Rights for Children Alliance and another. Just Rights for Children Alliance and another versus S. Harris. It's a case where a person was arrested for on allegation that he was having some stored pornography. Therefore, there were several NGOs involving in protecting children from children's pornography being spread out, but unfortunately, multi number of medias were functioning at foreign countries are doing this sort of and is being being voluntarily loaded in our Facebook and WhatsApp messages. So therefore, instead of going through the entirety of judgment, I would like to invite your kind attention at paragraph 5, wherein computer forensic analysis report was published, clearly how these cell phones recordings were retrieved by using what method. Therefore, you have to go through this, compulsory must go through this paragraph about this memory card retrieval from the cell phone of the accused. Number one. Then question arises, I would like to read only the index for the number one. They say the storage of pornographic material involving child is an offence under section 15(1) as amended under Act 2019. POCSO Act was enacted 2012. This has been amended 2019 by adding section 15. This the offence involved is 15(1). Therefore, they say the courts must prima facie subjective satisfaction that material appeared to depict a child from perspective of any ordinary prudent man. That was there. Then they have also discussed section 67B of the Information Technology Act. Then they say fundamental facts to be necessary to invoke the understand the culpable mental state of the person who possesses the pornography. Then they say they have also deeply discussed about the constructive possession of an accused. Failure or omission to report the same would constitute the request act as res for the purpose of section 15 class 1. So possession, constructive possession, immediate control were discussed. Then in short crimes. What in short crimes? Concept and rational. In short itself means undeveloped or incomplete. The doctrine of in short crimes underscores the principle that the law does not merely respond to offences already committed, but also intervenes when a crime is in process of being committed, thus thereby protecting public order and safety. That was there. Then they say statutory presumption of section 30 POCSO Act can be invoked, which involves an offence under said act that records culpable mental state. So that is most important. You have to read section 30, which was discussed as paragraph 222. Then Information Technology Act was High Court erred in quashing the criminal proceeding without even properly perusing the charges and other material. A prima facie case was clearly made out, therefore the judgment was set aside. Then the question of arises always the court whenever we say ignorance of law. So the Supreme Court says ignorance of law can be pleaded. Ignorance of law can be pleaded subject to four categories. They say an ignorance or unawareness of any law. Next, such ignorance or unawareness must give rise to corresponding reasonable and legitimate right or claim. Then the existence of such right or claim must be believed bona fide, and the purported act sought to be punished must take place on the strength of such right or claim. It is only when all the four of these conditions are fulfilled, ignorance of law may be claimed. Then they say equity, law of equity. They say equity cannot supplant the law. Equity must follow the law if that law is clear and unambiguous. Therefore, all these most important things were discussed. They say suggestion made to Union of India to curb the child pornography, but we cannot curb it unless and until the United Nations Organization wing intervenes and curb the foreign activities. Then they say role of social media. So all these things must be understood. Kindly slowly go through 1 page or 2 pages daily and to understand the judgment. This will help to defend your cases or argue your cases even in other cases other than the POCSO Act, because ignorance of law may be pleaded subject to 4 conditions. What is constructive possession, immediate possession, so many things have been discussed. My dear friends, this judgment was pronounced on 23 September 2024. Dr. Dhananjaya Y. Chandrachud, Chief Justice of India, and J.B. Badriwala. So it's a most important judgment how this Just Rights for Children Alliance and other prepared SLP and succeeded. This is AR 2024, Supreme Court 5531, Just Rights for Children Alliance and another, S. Harris and others, multi-number of pages. Therefore, kindly, this is commencing, ending at page 5624, commencing at 5531. 5624. So more number of pages, every paragraph is most important for defense lawyer to understand the discussion. Multi-number of judgments were discussed, including court of the extreme jurist. I hope you are understand the best.